They packed her life into one suitcase, 3 sweaters, 1 pair of good shoes, a photograph. Then her sons drove Margaret Hollis, 71 years old, 43 miles down a Tennessee road, and walked her through sliding glass doors she would not walk back through on her own terms. Before they left, the older one squeezed her hand. "You'll be comfortable here, Mama." 11 days earlier, he had signed a purchase agreement for $2.3 million. The land her grandfather cleared with his own hands, her mother's life's work, sold, and Margaret didn't even know her name was still on the deed. They just needed her somewhere she couldn't interfere. What they forgot was their father. Robert Hollis had sat at that kitchen table 35 years ago and written something down, quietly, carefully, because he knew his sons. He loved them, and he planned around them. Margaret didn't know any of this yet, but the land did. Margaret Hollis woke every morning at 5:47 a.m., not because of an alarm. She had not used an alarm clock since 1987. She woke because the farmhouse woke, because the old oak floorboards in the hallway contracted in the pre-dawn cold and made a sound like a single knuckle cracking, and because that sound had been her signal for so long that her body had simply learned to expect it. She would lie still for exactly 1 minute, listening to the silence outside the window, and then she would swing her legs over the side of the bed and put her feet on the floor. That was how Margaret Hollis began every day on the Clover Ridge property. Feet on the floor. Present. Ready. The farmhouse sat on 14 acres in Harlow County, Tennessee, at the end of a gravel road that the county had never bothered to pave. The land had been in the Hollis family since 1952, when Margaret's father-in-law, Earl Hollis, had purchased it for $4,200 and a handshake. Earl had built the original 2-room structure himself, and every generation since had added to it. A back porch here, a second bathroom there, a proper kitchen with a window above the sink that looked out over the east pasture. By the time Margaret and her late husband Robert had raised their 3 children inside those walls, the farmhouse had become the kind of place that holds a family's entire shape. Every corner remembered something. Margaret knew every inch of it. She knew which step on the back staircase skipped if you put your weight on the left side. She knew that the kitchen window stuck in August because the wood swelled in the humidity, and that you had to lift the frame slightly before you pushed. She knew the smell of the east pasture after rain, something between iron and honey, and she could tell the difference between the wind moving through the white pines along the fence line and the wind moving through the old walnut tree by the barn. They made different sounds. Most people never noticed. Margaret always did. Her skill, the one that had defined her quietly for 50 years, was her hands. Margaret Hollis could repair almost anything, not in a rough, makeshift way, but with a kind of precise, patient competence that her husband had admired openly and her sons had taken entirely for granted. She reupholstered chairs. She repointed the mortar between the chimney bricks in the fall of 2019 at age 69 from the top of a wooden ladder she had owned since 1995. She kept a canvas roll of tools on the shelf above the washing machine, chisels, a small ball-peen hammer, a set of inherited awls from her own mother. And she used them regularly. There was nothing performative about it. She fixed things because things broke, and because waiting for someone else to fix them had never made sense to her. After Robert died in the spring of 2021, she kept the routine. She woke at 5:47. She made coffee in the same percolator they had bought together at a hardware store in Maryville in 1978. She walked the east fence line every morning before breakfast, checking the posts, noting which ones needed attention. She kept a small notebook in her coat pocket and wrote things down in pencil. Post 7, south corner, leaning, replaced before winter. She was not sentimental about the work. She was simply thorough. Her daughter Clara called every Sunday from Asheville, North Carolina. They talked for 30 or 40 minutes about the garden, about Clara's students, about nothing in particular in the way that people talk when the point is simply to hear a familiar voice. Her sons, Dennis, 48, and Paul, 45, called less frequently. When they did visit, which had become twice a year at most, they moved through the farmhouse with a particular kind of restlessness, as though the walls were too close. They ate quickly. They walked the property with their hands in their pockets, squinting at the acreage in a way that Margaret noticed, but chose not to name. The first sign came in October. Dennis called on a Wednesday evening, which was unusual. He asked, in the careful voice people use when they have rehearsed a question, whether Margaret had ever thought about simplifying. He used that word specifically, simplifying. He mentioned that maintaining 14 acres alone was a significant undertaking for someone her age. He mentioned that Paul agreed. He mentioned almost as an aside that there were some very good options available for women in her situation. Margaret said she was managing fine. She hung up and stood at the kitchen window for a long moment, looking out at the dark pasture. Then she went to the shelf above the washing machine, took out her canvas tool roll, and checked each tool in turn. She did not know exactly why she did it. She simply felt, without being able to articulate it, that it was the right thing to do. She put the tools back. She went to bed. She did not tell Clara about the call. The paperwork arrived on a Friday, not by certified mail, not through an attorney's office with a formal cover letter and a return receipt. It arrived in a plain manila envelope, the cheap kind, with the self-seal strip left on the farmhouse's front porch between the storm door and the main door, where Margaret found it at 6:02 a.m. on the morning of February 14th. There was no stamp. Someone had driven it out and left it by hand, sometime in the night or the very early morning, and had not knocked. That detail, the not knocking, was the one Margaret would return to for weeks afterward. Inside the envelope were 3 documents. The first was a letter, typed and signed by both Dennis and Paul, informing Margaret that they had jointly consulted with a family attorney and determined that, given her age and the scope of the property's maintenance demands, it was in her best interest to transition into supervised residential care. They had already identified a suitable facility, Cedarwood Senior Living in Grantsville, Tennessee, 43 miles away. A room was being held. The transition was scheduled for March 3rd, 17 days away. The second document was a residency agreement for Cedarwood Senior Living. It had a signature line at the bottom. Her name was pre-printed beneath it in small, neat capitals, Margaret Ann Hollis. The third document was a copy of the power of attorney she had signed in June of 2021, 6 weeks after Robert's funeral, when Dennis had driven down from Nashville with a folder of papers and a gentle, practiced explanation about how important it was to have these things in order while she was still sharp enough to make the decisions herself. She had signed because she was 68 years old and freshly widowed, and because her son had sat across from her at her own kitchen table and told her it was the responsible thing to do. She stood on the front porch in her coat and read all 3 documents twice. Then she went inside, put the kettle on, and sat at the kitchen table. The tea was ready in 4 minutes. She did not pour it. She called Dennis at 8 a.m. He answered on the second ring, which told her he had been waiting. She told him she was not going. He said, in the careful, patient voice of a man who has prepared for this specific conversation, that the decision had already been made. He said the power of attorney gave him and Paul the legal authority to act in her best interest. He said the property taxes on 14 acres were increasing. He had the figures. He said the farmhouse needed a new roof. He had an estimate. He said he was worried about her being alone out there. He said Paul was worried too. He said they both loved her very much and that this was not easy for any of them. Margaret asked him directly, "Have you done something with the land, Dennis?" There was a pause. Not long, perhaps 2 seconds, but long enough. He said, "Mom, this is about your well-being." She asked again, "Have you signed something?" He said, "We'll talk about everything on the 3rd. I'll come down personally." He hung up before she could speak again. Margaret sat at the table for another 20 minutes. The tea went cold in the cup. She did not notice. Then she stood up, found the name of a property attorney in the county directory, Gerald Fitch, Harlow County Property Law, Maryville, and called his office the moment it opened at 9. His assistant told her Mr. Fitch could see her the following Tuesday. Tuesday was 5 days away. She spent those 5 days doing what she always did, walking the fence line, checking the posts, writing in her notebook. But now she was also reading. She pulled out every document in the house that had Robert's name on it, the original deed, the 1978 purchase records, the insurance papers, the tax filings going back to 2003. She spread them across the kitchen table in chronological order and read each one with the same methodical patience she applied to everything else. She was looking for something, though she could not yet have said precisely what. She found nothing, not yet. Tuesday came. Gerald Fitch was 64 years old, soft-spoken, and direct in the way that property attorneys in small Tennessee counties tend to be when they have been practicing for 30 years and no longer see any advantage in being otherwise. He read the power of attorney document carefully, asked Margaret 3 questions, and then set it down on his desk. He told her the POA was broad enough that her sons could, in theory, make property decisions on her behalf. He told her that contesting it would require demonstrating either that she had signed under duress or that the document exceeded its intended scope. He told her that both were possible, but neither was fast. He told her the process would take months and would cost money she may or may not have liquid. He asked her if she had any reason to believe her sons had already taken a specific action regarding the property. She told him about Dennis's 2-second pause. Fitch wrote something down. He told her to come back Thursday with every property document she owned. He told her to touch nothing, move nothing, and change nothing at the farmhouse in the meantime. She drove home on the state road with both hands on the wheel and the heat turned up because the February afternoon was dropping fast. When she got back to the farmhouse, Dennis's car was in the driveway. He was not inside the house. He was standing in the east pasture, 40 yards from the back porch, talking on his phone. He turned when he heard her tires on the gravel. He raised one hand, a wave, or perhaps a warning. Then he kept talking. Margaret went inside. She made dinner. She did not go out to meet him. Dennis came in at 6 p.m. He sat at the kitchen table and told her, in a tone that had shifted from patient to firm, that the room at Cedarwood was confirmed, that the move was happening on March 3rd regardless, and that fighting it would only make things harder and more expensive for everyone. He told her Gerald Fitch was a good man, but that this was not a legal matter, it was a family matter. He left at 7:30 without eating. Margaret washed the 1 cup he had used for water. She dried it. She put it back in the cabinet. March 3rd came 9 days later. When Dennis and Paul arrived at 8 a.m., With Paul's truck and 3 flat-pack boxes, Margaret had 1 suitcase packed and waiting by the door. She did not argue. She did not perform. She picked up the suitcase herself, walked to Paul's truck, and got in the back seat. She had made a calculation. She would go. For now, she would go. But she had also told Gerald Fitch, in a phone call the evening before, that she needed one thing before she left: 24 hours alone in the farmhouse to collect personal belongings. Fitch had communicated this to Dennis's attorney as a reasonable humanitarian request. Dennis had agreed. He had no reason not to. The closing date was still 10 days away. What possible damage could one old woman do in 24 hours? They drove her to Cedarwood. They handed her the suitcase. Dennis squeezed her shoulder at the sliding glass doors. Paul looked at his phone. The doors closed. Margaret sat on the edge of the narrow bed in room 14 and looked at the wall for exactly 11 minutes. Then she called a taxi. She was back at the farmhouse by 4 p.m. She had told herself she was coming for her mother's quilt. That was the reason she had given Fitch, and it was true. The quilt was real, and she wanted it. But she had also come because of the kitchen table reading sessions, because of the things she hadn't found yet, because of the 2-second pause on the telephone in February. She moved through the house with purpose, not grief. She checked the kitchen, the bedroom, the hall closet. Then she went upstairs. The attic ran the full length of the house. It smelled of cedar and old paper and the particular mineral cold of a space that hasn't held warmth in months. Margaret pulled the string on the single hanging bulb and waited for her eyes to adjust. The cedar chest was where it had always been, against the north wall, under the low part of the roof line, half obscured by a box of Robert's old surveying books and a rolled canvas painting Clara had left behind in 1999. She moved the books. She lifted the lid of the cedar chest. The quilt was on top, folded in quarters, faded to the color of old cream. She lifted it out carefully and set it on the floor beside her. Beneath it were the things she expected: Robert's good winter coat that she had never been able to give away, a box of Christmas cards from the 1990s, Clara's baby shoes in a brown paper bag. She was about to close the lid when the false back panel moved. It did not fall dramatically. It simply shifted, a slow, hinged, less lean forward, 2 inches at most, as though the wood had been waiting for exactly this amount of disturbance to finally let go. The humidity of 35 Tennessee winters and summers had worked the panel loose from its housing, millimeter by millimeter, until this moment. The manila envelope came with it. It slid down the inside back of the chest and landed on the folded Christmas cards with a soft, dry sound. Margaret looked at it for a moment without touching it. The envelope was water-stained along one edge, brown tide marks from some long ago August, and sealed with a metal clasp that had gone slightly green with age. On the front, in Robert's handwriting, the tight, careful cursive he used for anything important, was written a single word: Margaret. She sat down on the attic floor. She did not take her coat off. She worked the clasp open with her thumbnail, lifted the flap, and looked inside. There was a document folded in thirds, and there was a note handwritten on a single sheet of ruled paper, clipped to the outside of the document with a rusted binder clip. She read the note first. It said, "To protect Margaret from anyone who would take this land, including our own children. R.H., March 1989. Margaret read it once. She read it again. Then she unfolded the document. She read for 6 minutes without moving. The attic bulb hummed above her. Outside, the wind moved through the white pines along the fence line in the way she had always distinguished from the walnut tree, that particular, rushing, layered sound. She had known that sound for 50 years. When she finished reading, she did not make a sound. She reached into her coat pocket, took out her phone, and opened the camera. She photographed every page, 12 photographs, each one steady and clear, taken by hands that did not shake. Then she folded the document back into thirds, put it in the envelope, worked the clasp closed, and placed the envelope in her purse, beneath her wallet. She picked up the quilt. She turned off the attic light. She walked downstairs. She did not call Fitch. She did not call Clara. She did not call anyone. She put the kettle on, and while she waited for it to boil, she stood at the kitchen window and looked out at the east pasture in the late winter light. The same pasture Dennis had stood in 3 weeks ago, talking on his phone, raising one hand when her tires hit the gravel. The kettle began to whistle. She poured the water. She sat down at the kitchen table, wrapped her hands around the cup, and for the first time since February 14th, the set of her jaw changed. Not a smile, something older and quieter than a smile. She had 11 days before the closing. She had 12 photographs. And she had something her sons had never once considered. Her husband's handwriting, 35 years old, calm and deliberate and completely, irrevocably on her side. The taxi driver who took Margaret back to Cedarwood that evening was a 67-year-old man named Hector Ruiz, who had been driving the county route for 11 years and who asked no questions, which was exactly what Margaret needed. She sat in the back seat with the quilt folded across her lap and her purse held close against her side and watched the Tennessee dark come down over the fields on either side of the state road. She counted the miles on the dashboard display, 43 miles back to the room with the narrow bed and the wall she had stared at for 11 minutes that morning. She used those 43 miles. She opened the notes application on her phone, the same phone she had used to take 12 photographs in an attic 40 minutes ago, and she began to write. Not in the careful, considered way she wrote in her property notebook. Faster than that. She wrote every name she could remember from Robert's legal affairs, the attorney who had drafted his will, the county recorder's office where documents were filed, the name of the title company that had handled their 1978 purchase. She wrote Gerald Fitch's name. She wrote the date on the codicil, March 14th, 1989. She wrote the name of the notary whose stamp she had seen at the bottom of the document, Wallace P. Drummond, Notary Public, Harlow County. She did not know if Wallace P. Drummond was still alive. She did not know if the duplicate filing Robert had referenced in the codicil's final paragraph, a true copy of this instrument has been filed with the Harlow County Recorder's Office on the date above written, was still on record after 35 years. She wrote, "Find Drummond. Find county record. Call Fitch at 8 a.m. Hector pulled into the Cedarwood lot at 8:51 p.m. Margaret thanked him, took the quilt, and went inside. She did not sleep until after midnight. She lay on the narrow bed in room 14 with her phone on her chest, rereading her notes, adjusting the sequence, thinking through the order of operations with the same systematic patience she had applied to the mortar between the chimney bricks. There was a right sequence and a wrong sequence. The right sequence mattered. She was not going to spend her one significant legal asset carelessly. At 12:17 a.m., she turned off the phone and put it on the nightstand. At 5:47 a.m., she was awake. Gerald Fitch answered on the first ring at 8:03 a.m. Margaret told him what she had found. She told him calmly and in sequence, the cedar chest, the false back panel, the envelope, the note in Robert's handwriting, the codicil, the 12 photographs. She read him the specific protective language from memory, said property may not be sold, transferred, encumbered, or developed in whole or in part without the written witness consent of Margaret Ann Hollis, whose signature must be obtained independently and not under any power of attorney or legal instrument held by another party. There was a pause on Fitch's end. He said, "Margaret, I need you to send me those photographs right now. All 12. Do not send them to anyone else. Do not mention this to your sons or anyone connected to them. Can you do that?" She had already opened her photo gallery. She sent all 12 while he was still talking. He told her he would call her back within 2 hours. He told her to stay at Cedarwood, to behave as though nothing had changed, and to eat breakfast. She ate breakfast. Oatmeal, which was the only thing on the Cedarwood morning menu that did not taste like it had been prepared in a different decade. She sat at a table near the window in the common dining room and looked out at the facility's small courtyard, a concrete square with 3 wooden benches and a dogwood tree that hadn't been pruned in several years, and thought about what Gerald Fitch was doing at this exact moment. He called back at 9:58 a.m. He had already been to the Harlow County Recorder's office. He had found the duplicate filing. It was there. Instrument No, 1989-4471, recorded March 19, 1989, filed under Robert James Hollis, cross-reference to the original 1978 deed. 35 years of county records, sitting in a climate-controlled filing room on the second floor of a building that Dennis and Paul had never once entered. Fitch's voice, when he called back, had changed in a way that Margaret recognized. It was the voice of a man who had been practicing property law for 30 years and had just found something he had not expected to find. He said, "Margaret, if these photographs match the recorded instrument, and I believe they will, your sons do not have a valid purchase agreement. They cannot have a valid purchase agreement. The POA they hold is explicitly carved out by this codicil. Every attorney who touched that sale should have found this filing." He paused. "I don't think they looked," he said. Margaret said, "I know they didn't look." Fitch told her he was filing for an emergency injunction to halt the property sale that afternoon. He told her the filing would be under seal initially. The sons would not be notified until the injunction was granted, which he expected within 24 to 48 hours given the clarity of the recorded instrument. He told her to sit tight. She thanked him and hung up. Then she asked the Cedarwood staff member if there was a room she could use with a table and some privacy. The staff member, a young woman named Brianna who wore her hair in a long braid and who had been the only person at Cedarwood to greet Margaret by name since her arrival, showed her to a small conference room used for family meetings. It had a rectangular table, 4 chairs, and a window that looked out onto the uncut dogwood. Margaret spread her documents across the table and began to work. She was not waiting. She was building. On the second morning at Cedarwood, Margaret was in the conference room again when Brianna knocked on the open door at 10:15 a.m. and told her she had a visitor. The visitor was a woman Margaret had never met, Diane Pruitt, 34 years old, wearing a county lanyard and carrying a canvas tote bag with a Harlow County seal on it. She introduced herself as a preservation officer with the County Historical Society and explained, with a slight self-consciousness that suggested she was aware of the oddness of this visit, that she was processing a heritage designation application on the Hollis farmhouse property. Margaret asked her to sit down. Diane explained that the application had been filed the previous week, not by Margaret, not by her sons, but by the developer's own surveying firm, which had needed to document the property's construction date and materials for a historic tax credit eligibility review. The application had landed on Diane's desk on a Monday. She had pulled the property history on a Tuesday, and on a Wednesday, which was yesterday, she had found something that had caused her to close her office door, read a document 3 times, and then drive 43 miles to a senior living facility to speak to a woman she had never met. Margaret asked what she had found. Diane opened her tote bag and placed a photocopied document on the table between them. It was Instrument No, 198904471, the duplicate codicil pulled from the county recorder's archive. She told Margaret that she had grown up in Clover Ridge, that her grandmother, Ruth Pruitt, née Garland, had lived for 40 years on the neighboring property, the 12-acre parcel to the east of the Hollis land, and that Ruth had spoken of the Hollis family with a particular warmth reserved for people who had been genuinely kind neighbors over a genuinely long time. Diane had heard the Hollis name her entire childhood. When she saw it on the application, she had felt the specific pull of a name that belongs to a real place in your memory. She said she had almost not come. She said she had told herself it was not her business. Then she said, "But my grandmother used to say that land remembers who belongs to it." I think she might have been right. Margaret looked at the photocopy on the table for a moment. Then she looked at Diane Pruitt and said, "How familiar are you with heritage designation timelines?" Diane said, "Very." Margaret said, "Sit down properly. We have some things to discuss." Diane pulled her chair in, took a legal pad from her tote bag, and uncapped a pen. For the next 2 hours, Margaret and Diane Pruitt sat at the conference room table in a senior living facility in Grantsville, Tennessee, and built the second layer of a legal framework that Margaret's husband had begun building 35 years ago in a farmhouse kitchen in Clover Ridge. Margaret talked about the codicil's language. Diane talked about the heritage designation application's legal effect on the property status. They drew a timeline together on the legal pad, the codicil's recording date, the developer's survey request, the POA signing in 2021, the purchase agreement date, the closing date 10 days away. When they were done, Diane looked at the timeline and said, "They built their entire plan on a foundation they never checked." Margaret said, "That's what happens when you assume." She was thinking of the cedar chest, of a false back panel, of 35 years of humidity doing its quiet, patient work. Gerald Fitch filed the emergency injunction on the afternoon of March 5th. The filing cited the recorded codicil, the specific protective language, and the invalidity of the purchase agreement on the grounds that the seller's authority to sign was legally constrained by an instrument that predated the POA by 32 years. He attached certified copies of Instrument No, 198904471. He attached Margaret's 12 photographs as corroborating evidence of the original document's existence and physical condition. The Harlow County Circuit Court granted a temporary restraining order on the morning of March 7th. Dennis found out at 11:23 a.m. that same morning when his own attorney called him. Margaret knew the approximate time because Fitch called her at 11:45 to tell her the tro had been served, and because she could hear in his voice, carefully controlled, professionally neutral, that the conversation with Dennis's attorney had been a specific kind of satisfying. She asked Fitch what Dennis had said. Fitch said, "His attorney says he's disputing the codicil's validity on the grounds that it may not reflect your husband's final intentions." Margaret said, "Robert filed that document in 1989 and never revoked it. In 35 years, he never revoked it." Fitch said, "I know. That's what I told them." She walked back to her room, put on her coat, and asked Brianna to call Hector Ruiz. She needed to go back to the farmhouse. Not to collect anything this time, to work. The farmhouse felt different when she walked in that afternoon. Not in any way she could have described to someone who hadn't known it for 50 years. It was simply that the house, which had been holding its breath since February 14th, seemed to exhale slightly when her key turned in the lock. She stood in the front hallway for a moment and let the cold cedar and plaster smell of it come back to her. Then she went to the shelf above the washing machine and took down her canvas tool roll. She started in the kitchen. The window above the sink, the one that stuck in August, needed its weather stripping replaced before the spring damp set in. She had noted it in October. She found the stripping in the supply closet and spent 40 minutes on the repair, working with the focused quietness of someone who knows exactly what they are doing. Then she checked the back porch boards. 2 of them had developed a lateral crack over the winter that would worsen with moisture. She marked them with chalk, a small X on each plank, and made a note. She was not fixing things because the house might soon be taken from her. She was fixing things because the house was hers, and because things needed fixing, and because work for Margaret Hollis was the most direct expression available to her of the belief that the future was worth preparing for. She stayed until 4 o'clock. She called Hector Ruiz. She went back to Cedarwood. She did this every day for the next 6 days. The staff at Cedarwood stopped asking where she was going. Brianna made sure a conference room was always available when Margaret needed it. The oatmeal remained adequate. Room 14's narrow bed remained narrow. Margaret did not complain about any of it. She was too busy. In the conference room, she and Diane Pruitt met 3 more times that week. Diane had submitted the formal heritage designation application to the State Preservation Board on March 6th, the day after the emergency injunction filing. The heritage application created an independent legal layer. Under Tennessee preservation statutes, any property under active heritage review was subject to a mandatory development freeze for a minimum of 90 days pending board evaluation. This freeze operated entirely separately from the civil injunction Fitch had filed. It was not subject to the same challenges. It did not require Margaret's name on it at all. It was simply the law, operating on its own logic, because a 34-year-old preservation officer had recognized the family name from her grandmother's stories. Diane told Margaret that the state board had acknowledged receipt of the application on March 8th. The 90-day clock had started. The closing date was March 13th. On the morning of March 9th, a process server arrived at Cedarwood Senior Living and asked for Margaret Hollis. Brianna came to find her in the conference room. Margaret folded the legal pad she had been writing on, placed it face down on the table, and walked to the front desk. The process server handed her a document. She signed for it. She waited until she was back in the conference room before she opened it. It was a civil filing from Dennis and Paul Hollis, jointly represented by a Nashville law firm, Crandall, Mears and Whitfield. The filing contested the emergency injunction on 3 grounds. First, that the 1989 codicil had been superseded by the 2021 POA, which they argued constituted a more recent and comprehensive expression of Robert's estate intentions as carried out by his legal heirs. Second, that Margaret's mental and physical capacity to manage property decisions was in question, and they were petitioning for a formal capacity evaluation. Third, that Margaret had removed the original codicil document from the property without authorization, constituting potential interference with estate assets. Margaret read the capacity evaluation petition twice. She set the document down on the table and placed both palms flat on the surface and looked at the grain of the laminate for approximately 30 seconds. Then she picked up her phone and called Gerald Fitch. She read him the 3 grounds. When she finished, there was a silence. Fitch said, "The first argument is legally weak. A POA cannot supersede a recorded property instrument. The third is frivolous, and they know it. The second one," he paused. "The capacity petition is designed to slow us down, not to win. They need to delay the hearing past the closing date. If they can get a 30-day evaluation period ordered by the court, they may be able to argue the TRO should be stayed pending the evaluation." Margaret said, "How do we stop that?" Fitch said, "We respond fast. I file a counter response by end of business today. I attach your property management records, the tax filings, the maintenance logs, everything you've kept. A woman who has been managing 14 acres alone, filing accurate county tax returns, and maintaining detailed written property records is not a woman whose capacity is legitimately in question. We bury the petition and documentation before the court has a chance to take it seriously." Margaret said, "I have a notebook." Fitch said, "I need every notebook you have." She had 3. She had the current one, the one she kept in her coat pocket, and 2 previous ones from 2022 and 2023 kept in the kitchen drawer beneath the phone charging station. She called Hector Ruiz. She was at the farmhouse within the hour. She found the 2 older notebooks exactly where she had left them. She found, additionally, a folder in the kitchen filing cabinet that she had forgotten, 5 years of handwritten maintenance logs she had kept at Robert's suggestion, dating back to 2018, each entry dated and specific. August 3rd, 2018, replaced East Pasture Gate hinge, #8 galvanized screws, hardware from Maryville True Value. November 12, 2020, chimney repointing, full west face, 3 bags Type S mortar. She stood at the filing cabinet and held the folder and understood, not for the first time in this story, that her husband had known something about the value of documentation that his sons had never learned. She drove the notebooks and the folder to Fitch's office herself. He had them scanned and attached to a counter response filing by 4:45 p.m. The court received it the next morning. Dennis arrived at the farmhouse on March 10th at 2 p.m. Margaret was there, replacing the marked porch boards. She heard his car on the gravel and kept working. She heard him get out, heard his footsteps on the porch, heard him stop. She kept working. He stood behind her for a moment and then said, in a voice stripped of its earlier patience, "Mom, you need to stop this. You're going to spend everything you have on legal fees, and you're going to lose, and you're going to end up with nothing. I am trying to protect you." Margaret drove the last nail into the replacement plank. She set down the hammer. She stood up. She turned and looked at her son. She said, "Your father protected me. 35 years ago, with a piece of paper and a notary stamp, he protected me from exactly this." Dennis said, "Dad didn't understand what the land would be worth," Margaret said. "He understood exactly what it was worth to me." She picked up her hammer. She went inside. Dennis stood on the porch for 4 minutes. She heard his footsteps, back and forth, 2 boards. Then she heard him go back to his car. Then she heard the gravel under his tires. She stood at the kitchen window and watched him drive away down the state road until his car was a small shape and then nothing at all. On the afternoon of March 11th, Gerald Fitch called Margaret at 3:17 p.m. with a particular quality of controlled urgency in his voice that she had not heard before. He told her to sit down. She sat. He told her that Diane Pruitt had called the county attorney's office that morning with a question about the heritage designation application's interaction with active civil litigation. The county attorney, Robert Slagle, who had been practicing in Harlow County for 22 years, had pulled the full property file to answer her question. In pulling the full file, Slagle had encountered instrument no. 188904471 for the first time. He had read it. He had then, being a thorough man, pulled the purchase agreement that had been filed with the county in connection with the developer's survey request. He had found a problem. The purchase agreement, signed by Dennis and Paul Hollis as sellers, with full authority claimed under the 2021 POA, had been processed by a Knoxville title company, Meridian Title and Escrow. Standard due diligence for a $2. $3 million rural property transaction required a full title search. Meridian's title search had been conducted by a contract researcher who had searched records from 1978 forward, but had used a digitized database that the county recorder's office had populated from physical records. A database that, due to a 2003 data migration error, was missing approximately 340 instruments recorded between 1987 and 1991. Instrument No. 188904471 was among the missing records. The title company had issued a clean title opinion based on an incomplete database. The purchase agreement had proceeded on the basis of that opinion. The developer, Crestline Development Group, Nashville, had paid a $220,000 deposit to a joint escrow account held by Crandall, Mears, and Whitfield, from which Dennis and Paul had drawn $180,000 in two tranches in February, distributed as $95,000 to Dennis and $85,000 to Paul. Robert Slagle had called the developer's legal team at 1:30 p.m. The developer's legal team had called Crandall, Mears, and Whitfield at 2:15 p.m. By the time Fitch called Margaret at 3:17 p.m., Crestline Development Group had formally rescinded the purchase agreement, citing title defect, and had issued a demand letter for the return of the full $220,000 escrow deposit, including the $180,000 that had already been distributed. Margaret, Fitch said, and she could hear in his voice the thing he was trying to keep professional. They are going to owe the developer $180,000 they have already spent. The purchase agreement is void. The title opinion was defective. Crestline's attorneys will pursue recovery against your sons personally for the drawn funds. Margaret sat very still on the narrow bed in room 14. She said, the title company missed the codicil because of a database error? Fitch said, a 2003 data migration that nobody ever corrected. She said, and the developer's own surveyor filed the heritage application. Fitch said, which put the property in front of Diane Pruitt, who pulled the full physical file, which is how Slagle found the instrument. Margaret said, so the developer's own tax credit scheme is what unraveled the sale. Fitch said yes. There was a silence. Margaret said, Robert would have found that funny. She thanked Fitch and hung up. She sat on the bed for a moment. Then she stood, put on her coat, and walked down the corridor to the Cedarwood Common Room, where a television was playing a weather segment and 3 residents were eating an early dinner. She poured herself a cup of coffee from the station by the window. The coffee was poor, but it was hot, and she stood at the window and looked at the unpruned dogwood in the courtyard and thought about a man who had sat at a farmhouse kitchen table in March of 1989 and written something down. He had not known about database migration errors. He had not known about heritage designation applications or tax credit schemes. He had simply written the truth down, clearly and carefully, and filed a copy with the county, because he believed that the truth, properly recorded, properly witnessed, would outlast whatever came against it. He had been right. On March 12th, one day before the now void closing date, the Harlow County Circuit Court heard arguments on the Tro. Dennis and Paul's legal team from Crandall, Mears, and Whitfield appeared. Fitch appeared for Margaret. The capacity petition had been separately addressed in a preliminary ruling that morning. Judge Helen Carver had reviewed Fitch's filing with the maintenance notebooks and property records and had declined to order an evaluation. Noting in her brief ruling that the petitioners had provided no clinical basis for the request and that the respondents' documented property management history did not support the petition's premise. That took 11 minutes of the court's morning. The Troe hearing took 44 minutes. Judge Carver was a compact, deliberate woman of 59 who had been on the Harlow County bench for 14 years and who had, during those 14 years, developed a particular quality of stillness when she was about to say something that would not be appealed successfully. She sat at the bench and read Instrument No. 1-889-04471 in its entirety while both legal teams waited. She read the county's record of the instrument. She read the purchase agreement. She read the POA. Then she set everything down and looked at the Crandall. Mears and Whitfield attorney, a 41-year-old man named Travis Locke, who had driven up from Nashville that morning in a car that cost more than most of the county's residents made in a year. She said, "Counselor, the protective language in the 1989 instrument explicitly excludes any transfer of authority by power of attorney. Can you point me to any instrument, filing, or legal action that revoked or superseded this codicil between its recording date of March 19th, 1989 and the present?" Travis Locke said that the 2021 POA represented a more recent expression of the decedent's estate intentions. Judge Carver said the decedent recorded this codicil in 1989. He died in 2021. In the 32 years between recording and death, he took no action to revoke or modify this instrument. That is not ambiguity, Counselor. That is a 32-year statement of intent. She converted the temporary restraining order to a permanent injunction. She set a hearing date for the full civil case, the question of the purchase agreement's validity, and the recovery of the $180,000 for May 7th. She adjourned at 11:52 a.m. Margaret was not in the courtroom. Fitch had told her she did not need to be, and she had taken his advice and had instead spent the morning at the farmhouse replacing the 2 chalked porch boards she hadn't finished on the day Dennis had come to argue and found her with a hammer. Fitch called her at 12:08 p.m. She was on the back porch brushing sawdust off her coat. He told her the result. He told her about the 32-year statement of intent. He told her about Travis Locke's face when Judge Carver said it. Margaret said, "Good." She brushed the last of the sawdust off her sleeve. She went inside and made lunch. The first week of April came to Clover Ridge the way it always did, tentatively, in fits and starts, with cold mornings that gave way to afternoons warm enough to work in a light jacket. The east pasture, which had been the color of old straw since November, began to show the particular pale green that comes up through Tennessee grass when the ground temperature finally decides to commit. Margaret noticed it on a Monday morning during her fence line walk, the way she always noticed it, and wrote nothing in her notebook about it because some things do not need to be recorded to be remembered. She had moved back into the farmhouse on March 15th. The permanent injunction made the move simple in a legal sense. In a practical sense, it meant calling Hector Ruiz one final time, collecting the single suitcase from room 14, and thanking Brianna, who had maintained access to the conference room, kept Margaret's coffee preferences on a mental list, and asked no questions for 12 days, with a handwritten note and a tin of shortbread that Margaret had made in the farmhouse kitchen the night before. Brianna read the note at the front desk and put the shortbread tin on the staff counter and told her colleagues that Mrs. Hollis from room 14 had gone home. Nobody at Cedarwood was surprised. Margaret settled back into the farmhouse with the same quiet efficiency she had packed it. She put the quilt back on the bed. She rehung her mother's photograph, Edith Garland Hollis, standing on the front porch in the summer of 1967, one hand shading her eyes, looking at something off-frame with an expression of calm assessment in its place on the hallway wall. She restocked the kitchen from a Maryville grocery run. She refilled the percolator, set it on the stove, and stood at the kitchen window while it worked, watching the east pasture come back to its pale spring green. She was home. But she was not finished. The civil hearing was set for May 7th, 7 weeks away, and the question before the court on that date would not simply be the codicil's validity, which Judge Carver had already established. The May hearing would address three interconnected matters: the formal voiding of the purchase agreement, the question of the $180,000 in drawn escrow funds and their recovery, and Fitch had added this to the filing in early April, after careful consultation with Margaret, a claim for breach of fiduciary duty by Dennis and Paul Hollis in their capacity as POA holders, on the grounds that they had used the instrument to pursue a transaction that was explicitly prohibited by a recorded legal instrument they had a duty to discover. Margaret had asked Fitch, when he explained the breach of fiduciary duty claim, what it could mean in practical terms. He had told her personal liability, potential damages, a permanent legal record. She had said, file it. In the weeks between mid-March and the end of April, Margaret did three things simultaneously, with the same organized efficiency she brought to everything. She continued the farmhouse repairs, working through her chalk-marked list methodically, replacing the porch boards, addressing the east fence posts, beginning the preliminary work on the roof assessment that would need to happen before summer. She met twice more with Diane Pruitt, whose heritage designation application was progressing through the state board review process with what Diane described as unusual speed, given the quality and completeness of the documentation, and she called Clara. The call to Clara happened on a Sunday evening in late March, which was their usual time, but this call ran for 2 hours and 14 minutes instead of the usual 30 or 40. Margaret told her daughter everything in sequence, from the February envelope on the porch, to the cedar chest, to the attic floor, to Judge Carver's courtroom. She told it plainly, without dramatics, in the way she told most things. Clara listened. She did not interrupt. When Margaret finished, there was a silence on the line that was not uncomfortable, just full, the way a room goes full when something important has been said in it. Clara said, "Mom, why didn't you call me in February?" Margaret said, "Because I didn't know what I had yet. And I didn't want you to drive 400 miles for something I hadn't handled yet." Clara said, "I'm driving up." Margaret said, "I know." Clara arrived on a Friday afternoon in the first week of April in a green Subaru that needed its rear wiper replaced. Margaret noted this immediately and fixed it Saturday morning, while Clara was still asleep, with a replacement blade from the supply closet. Clara walked out onto the front porch with coffee and found her mother on a step stool at the rear of the car, pressing the new blade into its housing with the focused competence of someone for whom this was not a favor, but simply a fact that needed addressing. Clara stood on the porch and watched, and then said, "You are completely unbelievable." Margaret said, "The old one was splitting. You'd have had no visibility in rain." Clara stayed for 10 days. The town of Clover Ridge had known something was happening with the Hollis property since March. Small county, one recorder's office, a courthouse where the staff knew everyone's business, not through malice, but through proximity. The Trove filing had been public record. The permanent injunction hearing had been attended by, among others, the editor of the Harlow County Courier, a twice-weekly paper with a print run of 2,200 and a readership that significantly exceeded that number because copies circulated in ways that print run figures never fully capture. The Courier had run a brief item in its March 16th edition, Circuit Court Issues Permanent Property Injunction and Hollis Estate Dispute. It was 4 paragraphs, factual, and appeared on page 7 below an advertisement for a feed store. By April, it had moved in the way that significant local stories move in small counties person to person, across back fences and church parking lots and the counter of the Maryville True Value hardware store where Margaret had been buying supplies for 30 years. The woman behind the counter there, June Petty, 63, who had known Margaret since a 1994 conversation about the correct gauge of screws for exterior cedar, had started setting aside materials she thought Margaret might need before Margaret called to order them. She did this without being asked and without making anything of it. She simply did it. That was how Clover Ridge worked when it decided someone was worth working for. By the third week of April, two of Margaret's neighbors, Carl and Susan Whitmore, who farmed the 22-acre property directly north of the Hollis land, had stopped by twice with food and once with Carl's truck in 4 hours of his Saturday afternoon, which Margaret put to use helping her clear and repile the wood stack on the north side of the barn. Carl worked without talking much, which Margaret appreciated. Susan left a covered dish on the porch each time without knocking, which Margaret also appreciated. The farmhouse was becoming, slowly and without announcement, the thing it had always been when it was at its best, a place that the county recognized as worth keeping. Diane Pruitt's heritage designation application received a preliminary favorable review from the state board on April 22nd. The board's assessor, a man named Thomas Briley from the Nashville office, had driven out to Clover Ridge on April 18th to conduct a site evaluation. Margaret had walked him through the farmhouse herself, the original 1952 foundation structure still visible in the basement walls, the hand-cut timber framing in the attic, the kitchen addition from 1971 with its original wide plank oak floor, the chimney brickwork that dated to the first construction. She showed him the hallway photograph of Edith Hollis on the porch in 1967. Briley had taken 47 photographs and 3 pages of notes. He had told Margaret, as he was leaving, that the property was one of the most intact examples of mid-century rural Tennessee vernacular farmhouse architecture he had assessed in several years. Margaret had thanked him and gone back to her fence post. The preliminary favorable review meant the heritage designation process was now formally advancing. It also meant that the 90-day development freeze was confirmed through at least late June. The developer's legal team, which had been quiet since the purchase agreement rescission, went entirely quiet after the board's favorable review notice was published. Crestline Development Group was no longer a factor in this story. They had their lawyers and their demand letter and their $180,000 problem, and they had moved that problem entirely onto Dennis and Paul Hollis, where it sat like a stone neither son could lift or put down. On the last Sunday of April, Margaret was in the attic. She had not been back up there since the February night she had found the envelope. She went now with purpose, not to look for anything, but to begin the work of addressing the space properly. The false back panel of the cedar chest needed to be properly resecured. The chest itself needed cleaning. The attic floor had 3 boards that wanted attention. She worked for 2 hours. She resecured the panel with 2 small brass screws from the canvas tool roll, set flush and clean. She cleaned the cedar chest with a dry cloth, the way her mother had shown her. She chalked the 3 floorboards. Before she went back downstairs, she stood for a moment under the hanging bulb and looked at the space. It had held the envelope for 35 years. It had held the quilt, Robert's coat, Clara's baby shoes. It had held the shape of a family the way all attics hold the shape of families, quietly, without recognition, doing the work that nobody sees. She turned off the light. She went downstairs. She called Gerald Fitch and told him she was ready for May 7th. Fitch said, "I know you are." He paused, and then he said something he had not said before. In a voice that had stepped slightly outside its professional register, "Margaret, in 30 years of property law, I have never had a case where the evidence was this clean. Your husband built something in 1989 that held for 35 years. That doesn't happen by accident." Margaret stood at the kitchen window. The east pasture was fully green now. The white pines along the fence line moved in the late April wind in the way she had always known, that particular layered, rushing sound, different from the walnut tree, different from anything else. She said, "No, it doesn't." She thanked him. She hung up. She had 7 days. The Sons still had their Nashville law firm. They still had Travis Locke and his counter-arguments and whatever legal motion Crandall, Mears, and Whitfield had been preparing since the permanent injunction. They still had, in theory, the argument that the codicil's language was ambiguous or that Robert's intent had evolved, arguments that Judge Carver had not found persuasive in March, but that a well-paid Nashville attorney would nonetheless bring to a May courtroom, because that was what well-paid Nashville attorneys were retained to do. Margaret knew this. She also knew what was in the envelope in her purse. She had read it a total of 9 times since February. She had it memorized. She knew every word Robert had written, including the ones in the personal note. The ones that were not legal language, not formal, not for the court. The ones that were simply a man speaking plainly about what he knew and what he feared and what he had decided to do about it. She knew those words by heart. She was ready to let a courtroom hear them. The Harlow County Circuit Court convened at 9 a.m. on May 7th. Margaret arrived at 8:35 a.m. in the same coat she had worn to the attic in February. She carried her purse. Inside the purse was the manila envelope, the clasp refastened, the water stain along its edge unchanged. She had considered leaving the original at home and bringing only the photographs and the certified county copy. She had decided against it. Robert had written that document for her specifically, by name, in his own hand. She was going to carry it herself. Gerald Fitch met her on the courthouse steps. He was wearing a dark suit and carrying a leather briefcase he had owned since 1998. He looked at her and said, "How are you?" She said, "Ready." They went inside. The courtroom was not large. Harlow County Circuit Court occupied the second floor of a building constructed in 1937, with tall windows on the south wall that let in a particular quality of morning light that fell across the gallery benches in long, pale rectangles. The gallery held 12 people. Diane Pruitt in the second row, Clara beside her, Carl and Susan Whitmore near the aisle, and several others whose names Margaret knew from 30 years of county life. June Petty from the hardware store was there. Thomas Briley from the State Preservation Board had driven down from Nashville and sat in the back row with a notepad. Dennis and Paul sat at the opposing table with Travis Locke and a second attorney from Crandall, Mears and Whitfield, whose name Margaret had not bothered to learn. Dennis was in a navy suit. Paul was looking at the table. Neither of them looked at their mother when she walked in. Margaret sat down. She placed her purse on the table in front of her. She folded her hands. Judge Helen Carver entered at precisely 9 a.m. Travis Locke argued for 41 minutes. He was skilled. Margaret gave him that. He built his case in careful layers, that the 1989 codicil, while properly recorded, had been executed under conditions of legal ambiguity regarding its scope, that the 2021 POA, signed voluntarily by Margaret herself, represented a superseding expression of the family's collective estate management intentions, that Margaret's own signature on the POA constituted informed consent to the kind of property decision her sons had subsequently made. He introduced a property law expert from Vanderbilt who testified for 14 minutes about the interpretive hierarchy of conflicting estate instruments. He was thorough. He was expensive. He had prepared for this. What he had not prepared for, what Crandall, Mears, and Whitfield, in all their Nashville competence, had not thought to prepare for, was the personal note. Fitch had not told the opposing counsel about the note. It was not concealment. The note was not a separate legal instrument. It was a personal communication clipped to a legal instrument, and its content had been available in the 12 photographs Margaret had sent Fitch on the night she found the envelope. It was in the record. It had simply not been emphasized. Fitch emphasized it now. He read it into the record in full, slowly, in the quiet courtroom, with the May morning light falling across the gallery benches. To protect Margaret from anyone who would take this land, including our own children. R.H., March 1989. He let the sentence sit in the room for a moment before he continued. He told the court that this note was not ambiguous, that it did not require interpretive hierarchy or state law expertise, that Robert James Hollis had written, in plain English, in his own hand, in March of 1989, that the protective instrument he was recording that day was specifically intended to operate against his own children if necessary, that the phrase including our own children was not rhetorical. It was, Fitch said, a direct anticipation of the precise circumstance now before the court. He then addressed the POA argument. He told the court that the 2021 POA had been presented to Margaret Hollis 6 weeks after her husband's funeral, during a documented period of acute bereavement, and had been described to her as routine estate paperwork. He submitted into evidence the text message Dennis had sent Margaret on the day of the signing, retrieved with Margaret's permission from her phone, in which he had written just some standard forms, Mom, nothing complicated, just keeps things organized for later. He submitted a second text, sent the same day to Paul, retrieved from a separate legal process Fitch did not explain in detail, but which had been legitimately obtained. She signed everything. Didn't even read the POA section carefully. The courtroom was very quiet after Fitch read that second text. Dennis's jaw moved. Paul was still looking at the table. Fitch told the court that a document signed under false pretense by a grieving widow who had been explicitly misled about its nature and scope could not be held to supersede a recorded instrument that had been in continuous legal effect for 32 years at the time of signing. He cited 3 Tennessee cases. He cited the county attorney's finding on the title defect. He cited the State Preservation Board's preliminary favorable review. He sat down. Judge Carver looked at Travis Locke. She said, "Counselor, does your client wish to respond to the text message evidence?" Travis Locke conferred with Dennis for 45 seconds in a whisper that was not quite quiet enough. Then he stood and said that the text messages were informal communications that did not necessarily reflect the legal character of the POA signing. Judge Carver looked at him with the particular stillness Margaret had noticed in March. She said, "She didn't even read the POA section carefully is not a characterization I find ambiguous, Counselor." She looked at her notes for a moment. Then she ruled. The purchase agreement between Dennis and Paul Hollis and Crestline Development Group was declared void in its entirety, on the grounds that the sellers had lacked the legal authority to execute it under the constraints of Instrument No. 189-04471. The 2021 POA was ruled invalid as applied to the Clover Ridge property on the grounds of both the recorded instrument's explicit exclusion and the fraudulent misrepresentation of the document's nature at signing. The breach of fiduciary duty claim was sustained. Dennis and Paul Hollis were held jointly and personally liable for the $180,000 in drawn escrow funds to be repaid to Crestline Development Group within 90 days. A formal referral was made to the county attorney's office for review of potential elder financial abuse statutes as applicable to the POA procurement. The deed to the Clover Ridge property, 14 acres, farmhouse, barn, east pasture, the white pines along the fence line, was ordered to be re-registered solely in the name of Margaret Ann Hollis within 30 days through the Harlow County Recorder's Office. Judge Carver adjourned at 11:34 a.m. Dennis stood up from the table before Travis Locke could speak to him. He stood with his hands at his sides, and he looked across the room at his mother for the first time since she had walked in. His face held something that was not quite the thing people perform in courtrooms, not theater, not calculation, something older than that, something that had been there a long time under everything else. He took one step toward her table. Margaret looked at him. She did not move toward him. She did not speak first. She simply waited, with the same quality of waiting she had brought to the kitchen table in February, and to the attic floor, and to the narrow bed in room 14. Dennis said, "Mom." She said, "I know." 2 words. Level. Not hard and not soft. The words of a woman who has understood something for a long time and has chosen, in this moment, not to add to it. She picked up her purse from the table. She stood. She walked to where Clara was standing at the gallery rail, and Clara put both arms around her, and Margaret led her. Over Clara's shoulder, she could see the south windows and the May morning coming through them in long, pale rectangles across the empty gallery benches. She did not look back at her sons. She had said what needed saying. 2 words were enough. The brass plate arrived on a Tuesday in late June. Margaret had ordered it from a metalworking shop in Maryville. A man named Ed Cousins, who had been making custom signage for 40 years and who had asked no questions about the job beyond the dimensions and the text. She had written the text on a notepad and slid it across his counter, Hollis and Daughters Farm, Est. 1952, restored 2024. Ed had called her when it was ready. She had driven to pick it up herself. She mounted it herself too. 2 brass screws, countersunk flush, level checked twice with a small torpedo level from the canvas tool roll. She stood back and looked at it for a moment. Then she went inside and put the kettle on. The heritage designation had been formally confirmed by the state board on June 3rd. The farmhouse was now listed on the Tennessee Register of Historic Places, the 4th property in Harlow County to receive the designation, and the oldest continuously family-occupied structure among them. Diane Pruitt had driven out to deliver the confirmation certificate in person, which Margaret had not asked her to do, but which she received without surprise. She had made coffee. They had sat at the kitchen table for an hour. Diane had asked her what she was going to do with the designation. Margaret had said, "Keep it. Maintain it. Leave it better than I found it." Diane had nodded as though this was exactly the answer she had expected. Clara had come back in June and stayed. Not permanently. Her life in Asheville was her own. Her teaching position was her own, and Margaret had not asked her to give any of it up. But Clara had taken the summer. She slept in her childhood bedroom, the one with the east-facing window that caught the morning light first, and she and Margaret developed a new version of the old routine. 2 women in a farmhouse kitchen at 5:47 a.m. The percolator working, the east pasture visible through the window above the sink. On the first Saturday of July, Carl and Susan Whitmore came with their truck, and 3 neighbors Margaret had known for decades came with tools and lumber and a willingness to work, and they spent the day repairing the barn roof together. Nobody organized it formally. Carl had simply mentioned it at the feed store, and people had shown up. That was how Clover Ridge worked. By noon, there were 7 people on and around the barn, and someone had brought a cooler, and Susan had arrived with a second covered dish that she this time brought inside and put on the kitchen table without being asked. Margaret worked alongside them the entire day, not supervising, not directing, simply working, because that was the only way she knew how to be among people she respected. At the end of the afternoon, when the last of the neighbors had driven back down the gravel road, Margaret stood at the back porch railing and looked at the repaired barn roof in the long July light. Clara came and stood beside her with 2 cups of coffee. They stood there without talking for a while. The civil judgment against Dennis and Paul had been entered in the permanent court record on May 19th. The $180,000 repayment to Crestline was on a court-ordered schedule. The county attorney's elder financial abuse review was ongoing. Fitch had told Margaret the review could result in criminal referral, or it could result in nothing, depending on the prosecutor's determination, and that she should prepare for either outcome. She had said that she had not filed the breach of fiduciary duty claim to determine her son's fate. That was the court's business. She had filed it because the record needed to be complete. She had not spoken to Dennis since the 2 words in the courtroom. She had not spoken to Paul since before February. She did not know, in the quiet of the farmhouse evenings, exactly what that distance would eventually become. Whether it would harden, or whether, in some year she could not currently see, one of her sons would drive down the gravel road and knock instead of leaving an envelope between the doors. She kept the possibility open the way she kept the front gate oiled, not expectantly, but correctly. Because things should work when they are needed. On a morning in the last week of July, Margaret woke at 5:47 a.m. The oak floorboards in the hallway contracted in the pre-dawn cold. The sound came, one knuckle cracking, familiar as her own name, and she lay still for exactly 1 minute, listening to the silence outside the window. Then she swung her legs over the side of the bed and put her feet on the floor. She dressed. She went downstairs. She filled the percolator and set it on the stove. While it worked, she stood at the kitchen window and looked at the east pasture in the gray pre-dawn light. The fence line straight and sound, the white pines along its edge beginning to show their color as the sky came up behind them. She put on her coat. She took her notebook from the pocket. She went out the back door and began her fence line walk. At post 7, south corner, the one she had first noted in October, the one that had started all of this without knowing it, she stopped. She took out her notebook and a pencil. She checked the post. It was solid. She had replaced it herself in April, set 2 feet deeper than the original, tamped firm, level on all sides. She wrote nothing in the notebook. She put it back in her pocket and kept walking. The white pines moved in the early morning air, that particular layered rushing sound that was different from the walnut tree, different from everything else, and Margaret Hollis walked the full length of her fence line as the sun came up over Clover Ridge, on land that had been in her family for 72 years, on land that would remain so, on land that remembered exactly who belonged to it. She had 14 acres. She had a brass plate on the door. She had her mother's photograph on the wall and her husband's words on a county record that would outlast everyone in this story. She had her coat and her notebook and her canvas tool roll on the shelf above the washing machine. She had enough. She always had.